Good morning, everyone. Welcome to our first compliance forum webinar for 2024. Most of you will know already, but I'm Chris Finney. I'm one of the partners in the non-contentious financial services regulatory team at Fox Williams. I'm joined this morning by Sona Ganatra, who's co-head of our practice, and she's mainly on the contentious side of our team. Sebastian, also a partner in our team and on the contentious side, and Andrew Marra, one of the senior associates in our financial services regulatory group. This morning, Sona, Seb and Andrew are going to take us through some of the PRA and FCA enforcement notices and fines from last year. Have a look at the PRA and FCA current strategic priorities for the coming year, and then extrapolate from those, have a look at the likely direction of travel for PRA and FCA enforcement and financial crime investigations through 2024. We're recording this session. Please do pop your questions into the system, and we'll pick those up at the end, time allowing. Sona, would you like to take us away?
Brilliant. Thank you, Chris, and good morning, everyone. So as Chris said, this is our year in review session, which we've run now for a couple of years. And it's really interesting, actually, looking back and seeing how we've sort of predicted what's going to happen over the course of the year and what then does actually come out of the regulator. So as Chris said, what I'll be doing in the beginning part of this session is just giving you a bit of an overview of the sort of activity levels and the sorts of things that we've seen come out of the regulator. And then Seb's going to pick up and then take us through some of those cases in more detail and start picking up on some of the more practical things that you can take away from those cases. And then Andrew's going to cover us off at the end with a bit of a look ahead at 2024 and see what we can expect coming out of the regulator. Next slide, please. Brilliant. So how has the FCA performed? So let's kick off with them. So before we sort of go into and sort of think about how well they've performed, it's important to sort of look back and say, well, what is it that the FCA said it was going to do during the course of this year, of 2023? So if we look back to the 3-year strategy plan, which you'll know was launched in 2022, what the regulator then did was set out a few areas, 3 areas of key focus for it going forward. And one of those was the reduction and prevention of serious harm. And that's where we thought we would see the real sort of the brink of the brunt of all the enforcement cases. And what the regulator said was that it wanted to become this sort of proactive and effective regulator. We should expect it to see it acting faster and challenging themselves and using the wide range of its powers in order to remove firms that it thought were being disruptive or problematic. So that was the sort of backdrop, and what the FCA said is by year 2, so 2023, we should expect that strategy to have bedded down and the FCA to be really focusing on what they called the bigger, more complex firms, having sorted out the sort of low-level issues in 2022. So in terms of how that played out in areas of focus, it said that it was going to focus on a number of different areas, and one of those obviously being financial crime. So that's not new. For those of us who've worked in this industry, we've seen that that's been a focal point of the regulator for a number of years now. But what it did say, which is sort of in contrast to before, is that it would be using and looking at using its criminal powers to prosecute firms and individuals, as well as focusing on crypto assets, which are becoming partly anyway under the sort of purview of the regulator. It also said it would look at market misconduct, ESG. So what we mean by that is sort of instances of greenwashing, as well as a focus on the sort of social and governance side. And that's where it's focused on D&I and accelerating change that we've seen come through in the messaging was really focused. And as well as that, they said they would also be looking at focusing on redressing customers for harm that's been caused and improving oversight of problematic firms. Now, that's the sort of focus areas that the FCA said it would look at. And also, we also had, at the same time, 2 new directives of enforcement start in 2023. And I know Andrew's going to pick up on some of these points later, but for now, I thought what was interesting is right at the beginning of the tenure, Therese Chambers made some comments around how they would be approaching enforcement, and I thought it was important to draw on them now because of some of the themes that will come through later. One of them was that she obviously started off in saying that, they would be continuing this robust approach to enforcement in line with their strategies. But she said, focus on something about doing the right thing. And it became a bit of a buzzword last year. And part of that was that she said firms should really focus on being proactive and cooperative and taking responsibility for their actions. And she said that firms that did that would be sort of praised and treated well by the regulator. They would see the benefits of discounts and sort of faster action. And interestingly, she also picked up on the actions of lawyers and said, we all know that you're tempted to take these big points and pick up on every single issue, but actually that's not going to help your client at all. You should be focused on trying to be proactive, getting to a resolution, and that's what will make sure that the process runs more smoothly. So it's quite interesting that she sort of started the year with that approach. So let's see how that actually played out. Next slide, please. So in some respects, it was what we expected to see. So we had a total of 8 final notices, 2 against 2 against individuals and 6 against firms, and a total number of penalties levelled around the sort of 52 million. And Seb's going to talk in more detail about some of the cases later on, but for now I just wanted to draw on the fact that the types of issues that came through were exactly in line with the strategy and what we expected. There was a big focus on money laundering, financial crime. There was also a big case around cybersecurity. Interestingly, though, there was also things that we didn't expect to see, which I think is quite important to draw out. There was no fixed case on SMCR. Again, and we've talked about this over the past few years in these sessions, and I was looking back and thinking about what we talked about last year and the year before, and each time we've predicted there will be more SMCR cases. They're finally going to make their way through, and they haven't. And so Seb's going to talk about Jess Daly. We've seen a return of this year, but he'll pick up on what's going on with that. But that is a real notable missing element to where the FCA have behaved over the year. And it's surprising because if you look back to 2023, my understanding is that there was around 60 or so open investigations into SMCR. And it seems that none of those have come through. And so this is something that I think that the regulator really does need to focus on. And although it wasn't sort of directly spoken about in their strategy, the FCA has spoken for many years about making sure individuals are held to account for the problems of their firms. And it's just notable that we still haven't seen that pull through in the enforcement action that's been taken. So at first blush, you might be forgiven for thinking, well, that's not actually very much that's come out of the regulator. So have they really fulfilled and lived up to their strategy? And Nikhil Rathi last year was sort of quoted in a speech as saying that they've had a fantastic year and they're really meeting all of their objectives. So is that really true? Actually, when you dig a little bit deeper, it's not just those 8 final notices that the regulator's been focusing on. And actually, there has been quite a lot of activity. And so I've mentioned some of the different things that have come out of enforcement there. I won't go into too much detail about the pensions cases for today, but suffice to say that actually there was sort of 14 different outcomes there against individuals and firms and prohibition orders and penalties, just picking up on those the action against those involved in pensions transfers. But importantly, I wanted to pick up on the criminal prosecutions that have come out of the regulator. And actually, we've seen some real significant improvement there in terms of cases. So they actually convicted 7 individuals last year in relation to investment fraud and money laundering, and they actually commenced 15 new cases against individuals and firms for all sorts of elements of fraud, unauthorized activity, insider dealing and AML. So we're really seeing there that sort of focus on dealing with financial crime, but not through traditional enforcement route, but really picking up on this element of using their criminal powers. Staying with financial crime, they also use their powers under the money laundering regulations to shut down crypto ATMs. And again, this is that strategic focus on cryptocurrency firms where we know that the FCA is not being particularly happy and has some real concerns about the risk to consumers there. So they've been using their powers in a different way in relation to crypto. We also know that there's been an uptick in interventions. They've also removed over 10,000 misleading financial promotions, cancelled the permission of over 1,000 firms, and sent out warnings to unauthorised firms, around 2,000 unauthorised firms, I believe it is. So in some respects, actually, we've seen a lot of activity and far more engagement than I think we've seen in previous years. It's just interesting that it's not using the traditional powers of enforcement that we have seen in the past. And I think that's really the travel of direction of travel now that we should expect to see from the regulator. So next slide, please. So what is it that is causing the regulator to sort of move away from traditional enforcement and focus on using sort of their wider powers? So one of the things is it's still taking an extraordinarily long period of time to get through enforcement. Some of the stats that came through the annual report last year show that the average duration of a regulatory investigation is around 40 months and around 59 months for a criminal one. So you're thinking of, getting to close to 5 years before you see any sort of conclusion drawn from an investigation. Now, even the upper tribunal in one of their cases criticised the FCA for this and said taking over 5 years to investigate individuals is just not acceptable. And it suggested that the FCA really reconsider whether it is appropriate for them to take cases where they just don't have the resource to actually investigate them swiftly and promptly. And it's interesting because if I look back to my experience sort of 10 plus years ago, around 2 years was around the norm sometimes for more straightforward cases in enforcement. And now it's taking obviously clearly double that at least. And we're really seeing that in some of the cases that we've been working on over the year. Some have been closed down at times where it doesn't quite make sense, and others have just really ground to a halt. But in our practice, where we have seen an uptick, is actually this use of different powers and the use of interventions to sort of shut down businesses in effect and get them to agree to restrictions, when actually traditionally we would have seen that play through enforcement. And because that's taking so much time, I think it seems to me that actually the regulator's saying, well, where can we get some quick wins? And in order to meet those stats and show that we're making progress, we're going to use other powers. And sometimes they're not necessarily using those powers in the right way or when it's appropriate to do so. One of the other things that I wanted to touch on was also the upper tribunal. Seb's going to pick up on some of the cases in a bit more detail if we have time later, but I thought it was important to pick up on it now because I think this has had a real chilling effect on enforcement and the sorts of activities that we've seen coming out of the enforcement team. So those of you who are sort of not necessarily familiar, the upper tribunal is of course the forum in which they hear contested action from taken by the FCA. And we've talked in previous sessions about the upper tribunal really in recent years becoming highly critical of the FCA. And that trend continued in 2023. And we had 3 cases of where actually it was quite scathing comments made about the enforcement process adopted by the FCA. In summary, they talked about the time that the FCA took, taking too long, and really that being highly unfair and prejudicial to the individuals and firms involved. They talked about the FCA not actually understanding or being clear in the action that they're taking and not setting out exactly why they thought certain breaches had taken place. And interestingly, in 2 of the cases, they just completely disagreed with the FCA, refused to hear additional grounds or take a different approach and just said, you've got it wrong here, which was quite an interesting and quite a blow really to the enforcement team. They also talked about continual failures in disclosure. And again, this is something that's come through before, that the FCA are not adopting appropriate processes when it comes to disclosure. They're not exchanging material that's undermining or putting evidence forward to the tribunal that would be helpful to the defendants. And not necessarily calling on witnesses and relying heavily on documentation or internal reports produced by the firm when it comes to taking cases against individuals. So what impact has that had? So I certainly think from my experience, it's encouraging firms to really sit back and say, well, actually, we might want to fight this. We might actually want to push back against the regulator. And picking up on something I said earlier about Therese Chambers saying, lawyers shouldn't be taking all these points and you've got to be proactive and sort of work with us. I think that that's sort of at odds with what firms are really wanting to do, because they are seeing the upper tribunal picking up on where the FCA are not actually following their own processes and adopting methods which aren't actually appropriate for the business. So I think we've seen a real uptick in firms wanting to take challenge against the FCA and actually seeing those come through. And Seb's probably going to mention some of this later. We've obviously got Jess Daly, who's referred to the upper tribunal. There's also a bank and some senior executives that have this year as well. And just taking a look at the the list of cases that have referred to the upper tribunal, you can really see that there is a backlog already. And we're looking at cases sort of going well into next year that are going to be heard by the upper tribunal. And I think that trend will continue and is something that we should certainly keep an eye on. And the observation that I would make is that the FCA really, I think, needs to start thinking quite carefully about how it improves its enforcement processes if it really is going to meet its strategic priorities, and being this sort of challenging and tough regulator that it wants to be. Next slide, please. So I'm going to move briefly to the PRA, where we've got a very different picture compared to the FCA. Things are far more straightforward here, and that's partly because obviously the number of firms that it regulates is smaller and the sorts of issues that it will be focused upon. So looking back to sort of areas of their sort of focus and priority, of course, there's no surprises here. It's issues such as, financial resilience, operational resilience, credit and risk management, and governance. And those are the sorts of issues that we've seen filter through the cases over the years. It's interesting because last year the PRA sort of had dropped in terms of the number of cases it was investigating. I think late last year it announced that it was looking into 7 cases that was involving 6 different firms and 11 related individuals. And that's smaller than or more in line with broadly what we've seen historically, but we'd seen a bit of an uptake tick in the last few years, and it seems to have dropped. And looking at the 3 cases that came out, they're clearly in line with their areas of priority. So we had one case around financial reporting and resilience, one to do with risk management and governance, and then we also had our first SMCR case. Seb's going to talk about this because there's some really interesting, I think, themes that came out of that particular case and areas of responsibility. But it was I think a relief to everyone to say, well, actually here is an SMCR case, and what issues can we and lessons can we draw from that. And I think interestingly what we've also seen is this continued move away from using and working alongside the FCA enforcement teams. Historically, both seem to work together in terms of investigations, and I think we've seen a real step away from that. And the enforcement team at the PRA has grown over years as well, so I think that trend will continue. And interestingly, they also launched a consultation last year about the approach to enforcement, and the PRA and Bank of England wanting to adopt sort of more streamlined approaches to how they would approach enforcement and where they would enter into early discussions around settlement. So I really think that we're going to see an even more marked difference going forward in the way that the PRA approaches enforcement compared to the FCA. And an observation I would make is that the FCA may want to sort of try and adopt some of those processes as far as possible if it really is going to get through this backlog of enforcement cases. So that's a bit of a whistle-stop tour of what we saw last year. I'm going to hand over to Seb now. He's going to sort of do a bit more of a deep dive into some of those cases.
Thanks very much, Sona. So if we can move on a couple of slides, please, Dan. So I'm going to try and take us through pretty quickly, I think, 6 different areas and some exciting FCA enforcement cases, which is what I know everyone's been waiting all year for. So if we can move through to the next slide, please, Dan. So financial crime. So I think there are about 4 or 5 cases that were kind of directly on financial crime. A couple of them I think we talked about last year because they came right at the beginning of the year. Those were Guarantee Trust Bank and our own bank. And we've set out the names on the slides, but some of the themes that kind of come through these cases are set out at the bottom. So no direct evidence of money laundering in these cases. So these aren't cases in which the FCA have said, look, you have poor systems and controls, and this has led to this crystallized instance of money laundering. These are, if you like, kind of theoretical things, and that's probably a difference why these aren't cases taken under the money laundering regulations and potentially criminal prosecutions. So what do these cases actually involve? So they're all involving breaches of Principle 2 and or Principle 3. So Principle 3 requires firms to take reasonable care to organise and control their affairs responsibly and effectively with adequate risk management systems. Principle 2 requires firms to conduct their businesses with due skill, care and diligence. And what these cases show is that it's not simply good enough for a firm to have systems and controls as required by Principle 3, but they also need to carefully apply those systems and controls with due skill, care and diligence as required by Principle 2. And if you don't, then the FCA will bring an enforcement case against you for breaching of both of those principles. So what do some of these cases actually involve? So inadequate onboarding checks, things like not performing proper customer risk assessments, pretty basic. But also once the customer is onboarded, not performing proper monitoring of transactions and also the ongoing customer relationship. So is the customer doing what you thought they would be doing when you first onboarded them? There were also in some of these cases firm-wide issues. So whilst there may have been those individual customer checks, there was no check over the firm as to what was happening. So no firm-wide money laundering risk assessment, for example. There may well have been old or outdated policies and general underinvestment in staff and in training in this kind of area. Also, all of these cases involved historic or repeated issues in this kind of space. So previous compliance failures, FCA visits saying that you're not performing well enough in this area. Some firms had previously had their permissions varied in relation to financial crime. And probably what this does show is that in some cases, the FCA will give you a second chance, but probably not a third and definitely not a fourth. So I would say if you're on their radar for this kind of thing, if you previously had visits and they've said you're not quite up to speed on financial crime issues, then really tighten up. Next slide, please, Dan. So pensions cases. So there were quite a lot of pensions cases this year, and these were in relation to defined benefit pension transfers, often linked to the British Steel pension scheme. And this has been a real area of focus for the FCA probably from about at least 2019. So it kind of shows you how long some of these enforcement cases do take to work through. And some of the common factors in these cases were failure to focus on customer objectives and failure to collect the necessary information from customers before advice was given to transfer out of a defined benefit pension scheme. And I had a case, not British Steel, but a pensions transfer case. And it was pretty interesting because I think going back to what Sona was saying about the FCA's kind of different use of powers, it really demonstrated that. So our client was in enforcement, investigation opened into them. The FCA tried to use some different powers, so tried to vary their permissions, for example, and then actually the enforcement case was discontinued, which was obviously good news for our client. Then they went into a very long, intensive period of supervision, which actually required a lot of work from the firm, and in some ways was more challenging than an enforcement case because there weren't necessarily timeframes, and it was a relatively small firm, and it had quite a big impact on them in terms of resource, and it was quite interesting to see the FCA using their powers in this way and being a bit more creative around how we're actually going to supervise even very small firms quite aggressively. And what was also interesting about this was and we've seen generally lots of FOS cases from the Financial Ombudsman Service in this area around pensions. And for our client, that they did have a few FOS claims against them. And whilst the FCA have effectively given them a clean bill of health, the enforcement and the intensive supervision both ended because the FCA was satisfied, the FOS have taken quite a different view. The FOS, some of you may have been through FOS processes, is a very different system to dealing with the FCA or dealing with the courts. It's supposed to be an informal system. The FOS doesn't strictly have to apply the law. They can effectively depart from FCA decisions. Their metric for deciding a case is what is fair and reasonable, and it can be very difficult to sway the FOS from what they think sometimes. The only mechanism to challenge the FOS is through a judicial review, which is very expensive and difficult to win. And now the FOS have powers to award up to £415,000 to consumers, which has significantly increased in recent years. And our experience is that some firms are simply finding, depending on the type of area, this just uninsurable and it's putting them out of the market. So what I would say is if you do get a FOS claim, you need to think about dealing with it really, really carefully in compliance with DISP, and it's actually worth seeking legal advice around it potentially. Next slide, please, Dan. So PRA enforcement. So Sona's touched on this already, and we'll just have a quick canter through some of the cases. So 3 last year and actually 1 at the beginning of this year. So Wylands Bank. So this was probably one of the more troubled banks that we've had. This is quite often actually in the mainstream press. So this case principally related to breaches of the large exposure reporting rules. But actually, perhaps more interesting were the PRA's criticisms about Wylands record keeping systems and controls. And I think it applies to everyone on this call because those are FCA rules as well. So what the PRA was partly looking at as part of this was the firm's use of unauthorized communications apps, specifically WhatsApp in this case, and also the use of personal devices by senior individuals. And the PRA identified that Wylands record keeping was really pretty poor. So it really stemmed from a lack of proper policies and procedures. So that was to do with managing the use of out-of-band communications apps for business-related communications. It was looking at how the bank retained business-related messages on mobile devices, regardless of whether they were issued by the bank or personal devices, and how the bank had systems to retrieve those business-related messages from mobile devices in a timely manner. And what the PRA found that the bank's directors and senior executives were regularly communicating over WhatsApp, and the lack of policies and procedures meant that Wylands Bank just had an inadequate oversight over these communications. And we've seen the comparison from politics and what's going on in the COVID inquiry now, and everyone knows how prevalent WhatsApp and things like Signal and Telegram are, but it's definitely an issue that's on the regulator's radar. So we've seen in the US last year, the SEC and FINRA fined firms, I think, about $2.8 billion in relation to the unauthorized use of unauthorized apps. And the FCA have come under a little bit of scrutiny for what they're doing in this area. They've said that they're closely monitoring this issue, and it's been reported in the press that they've engaged with firms already around this. So I think it's definitely an area that all firms should be looking at and tightening up their policies and making sure they're addressing things like WhatsApp. The next case is the case of Carlos Abarca. So he was the chief information officer of TSB Bank, and he was fined about 80 grand. And he was fined because of his failures in overseeing an IT migration project in 2018, which caused significant disruption to millions of customers. And he was found to have breached the senior manager conduct rule, which states that reasonable steps must be taken to ensure that the business of the firm for which he was responsible complied with the relevant requirements and standards of the regulatory system. And so it was the first PRA senior manager case under the SMCR for breaching the senior manager rather than the individual conduct rules. And probably what was interesting about this is these failures were primarily caused by an IT firm not regulated by the FCA, not regulated by the PRA, and yet the regulators had no hesitation in holding Mr. Rabaka responsible for that because it was within his area of responsibility. Finally, from last year, Credit Suisse. So in July, the PRA announced that it had fined Credit Suisse entities £87 million for significant failures in risk management and governance in connection with the firm's exposures to a client. And it was one of the highest fines by the PRA to date. And it's the only time a PRA enforcement investigation has established breaches of 4 of the PRA's fundamental rules. The PRA found that the firm's risk management oversight and practices fell well below the regulatory standards required, and failures were found to be symptomatic of an unsound risk culture within the business that had failed to balance considerations of risk against commercial reward appropriately. And finally, we come on to January of this year. So in this case was quite interesting, just for reasons of time, perhaps we'll cover it a little bit more next year. I'll kind of round up. But this was against the former CEO of Wylands Bank, so the first PRA case. And it's interesting probably for 2 reasons. So firstly, it set out against what reasonable steps looks like for an SMF. And second, in this case, Mr. Hunter offered to the PRA an undertaking to the effect that he wouldn't work in UK financial services again. So the PRA didn't pursue a prohibition. They didn't offer a view on whether he was fit and proper or not. And I think it's certainly only one of the cases I know where this is in recent times where this has been an approach that's been adopted by a regulator, rather than just saying, no, this is not a fit and proper person, we're going to ban you. So quite interesting, and it'll be interesting to see how much this comes up in other cases in the future. Next slide, please, Dan. So upper tribunal decision. So as Sona was saying, the upper tribunal is effectively the independent appeal from the RDC, from the FCA's decision-making processes. And one other interesting thing to perhaps note is sometimes individuals and firms are just simply bypassing the RDC. So rather than going draft warning notice from the FCA, contest that, we'll go to the RDC, contest it, we'll go to the upper tribunal. They're just bypassing that middle step and going straight to the upper tribunal. And again, some of these things that we'll talk about now may well encourage those types of referrals. So the 3 major decisions this year, Marku. So this was a case of an individual who was the sole director of a mortgage and insurance intermediary. The FCA said Mr. Marku wasn't a fit and proper person. The upper tribunal disagreed. And it said that although it found him to have failed to ensure that regulated activities had ceased after a time when required insurance was no longer in place, in its view, this had not been done recklessly or with a lack of integrity. And what was quite interesting, the upper tribunal declined the FCA's invitation for it to make alternative findings as to whether Mr. Marku had breached any other principles. And the upper tribunal determined that the appropriate action was for the FCA not to impose any financial penalty at all or any prohibition at all. And what came out after this was the FCA made a very strong public statement that it believed the upper tribunal's decision to be incorrect and irrational, to quote it, and said it would be seeking permission to appeal. And that kind of reaction to the upper tribunal is a bit of a theme that we'll discover. So next, the Julius Baer employees. So these were decisions against 3 individuals previously employed by Julius Baer, so a Swiss headquartered private bank. The FCA said all of these individuals, for different reasons, lacked integrity. The three individuals referred the FCA's decision to the upper tribunal, and the upper tribunal said it was not satisfied that the FCA again demonstrated recklessness or a lack of integrity, and ordered, in this case, the FCA to reconsider its decision. The upper tribunal made a number of quite helpful remarks that should go some way to clarifying what the appropriate test is in establishing recklessness. So it rejected the FCA's argument that a finding of recklessness could be made where a reasonable person would have appreciated the risk presented, and in fact held that it was necessary to show that the individual did actually appreciate the risk, and then would have to go on to assess whether it was reasonable in the circumstances for the individual to ignore it. The upper tribunal was particularly critical of a number of significant process points that Sona was touching on earlier. So, for example, in this case, relying heavily on the evidence of another individual without actually calling that person as a witness in the proceedings, the time taken for the FCA to issue their decision notice, the FCA's general handling of disclosure, the failure to ensure that potentially undermining evidence was placed before the upper tribunal, and I think this is a really important one, the extent of the FCA's reliance on the firm's internal investigation reports informing its case against the individuals rather than the FCA actually doing its own investigative work. Now, again, the FCA, after this decision, put out a statement saying they would appeal, and they strongly disagreed with the upper tribunal. And when a cost decision in this case was made in November of this year, the FCA said some quite extraordinary things. It says that the FCA's press statement after its original decision was highly misleading, and, to quote it, was disgraceful and should never have been made. The upper tribunal speculated on whether the statement showed a serious error of judgment on enforcement's part or a systems and controls failure by the FCA around statements issued by the FCA's communications teams. And the upper tribunal said, and to quote it, "I trust that never again will the authority seek to give such a misleading impression of the result of a tribunal decision, and it will act fairly, as it usually does, in summarising the results of a decision and providing an appropriate link to the decision." So pretty strong language. And finally, we come to Bluecrest. So this was a finding against a firm for alleged breaches of Principle 8 relating to a failure to manage fairly a conflict of interest. And again, this was slightly different because the upper tribunal was scathing of the FCA's original decision. So it said the FCA's decision notice was not an impressive document. It stated that it demonstrated a considerable lack of muddled thinking on the part of the FCA and a lack of clarity as to the reasons that the FCA came to the conclusion that it did. And it caused the upper tribunal to struggle to identify itself the essence of the FCA's reasoning. The FCA also tried to change its case midway through the process, which the upper tribunal was not very impressed with. So I would say some of the key takeaways from these cases are really that it's probably worth more than ever thinking about challenging the FCA at the upper tribunal level. It's also worth thinking about whether it's actually worth just simply expediting things and skipping out the RDC and going straight to the tribunal. So next slide, please. And so cryptocurrency. So I'll cover this fairly quickly. So these aren't enforcement cases, but again, I think it shows, as Sona was saying, that this kind of area of interest for the FCA. So there were at least 3 examples last year of the FCA in joint operations with the police and National Crime Agency visiting crypto ATMs across the country. So these were sites at which crypto ATMs were operating without proper registration. Operating without proper registration is illegal. That's a criminal offence. I don't think that there are any crypto ATMs that are actually properly registered yet. And when the FCA were putting out the press releases around this area, again, underlines the FCA's view that crypto products aren't currently regulated, they are high risk, and that consumers should be prepared to lose all of their money if they invest in them. So I think this just serves to underline that if you're dealing with crypto or your crypto business, you need to be really careful because you could well be on the FCA's radar. Next slide, please. So Jez Staley. So probably fair to say the FCA finally got their man. So Mr. Staley was the CEO of Barclays, and in 2018 they had fined him £642,000, so pocket change for him really, for failing to act with due skill, care and diligence, so breaching individual conduct rule 2, because of his personal conduct in relation to trying to investigate and personally uncover a whistleblower. And I think a lot of people at the time were very surprised that it wasn't a prohibition case. It wasn't an integrity rule 1 breach, but it wasn't. And then we come back round. So this case involved Mr. Staley's involvement with Jeffrey Epstein, the disgraced financier in America. And so this was a prohibition case, an integrity case. And the FCA said in this case that Mr. Staley recklessly approved a letter sent by Barclays to the FCA, which contained 2 misleading statements about the nature of his relationship with Jeffrey Epstein and their last point of contact. So the letter claimed that Mr. Staley didn't have a close relationship with Mr. Epstein, whereas in reality, emails between the two of them showed that Mr. Staley described Mr. Epstein as one of his deepest and most cherished friends. The letter from Barclays to the FCA claimed that Mr. Staley had ceased contact with Mr. Epstein well before he joined Barclays, whereas, however, in fact, he was in contact with him in just, I think, the days before his appointment as CEO was announced in, I think, December 2015. And whilst the FCA said that Mr. Staley didn't actually draft the letter, there was no excuse whatsoever for him not correcting the misleading statements when he was the only person in Barclays who knew the truth of their relationship, and he should have corrected that when he saw the letter, and that failing to correct these misleading statements recklessly misled the FCA, and therefore he acted with a lack of integrity. As someone said, he is appealing, and so we'll see what the upper tribunal has to say about that in due course. And I think that is me, and so I'll hand over to Andrew.
So looking at the direction of travel for enforcement investigations in 2024, you'll see from the slide the key areas we think the FCA and PRA will focus on, and I'll go through each of these in more detail now. So next slide, please, Dan. So starting with consumer protection, we expect the FCA to ramp up enforcement of its consumer protection regime in 2024, expanding its reach into more product areas and taking tougher action against companies that fail to meet standards. Now, the FCA's main priority, as we see it, will be its consumer duty regime, which came into force in July last year. And that requires firms to deliver good outcomes for retail customers. By way of reminder, consumer duty applies to all firms that have a material influence over or determine retail customer outcomes. And that applies across the whole distribution chain, from product and service origination through to distribution and post-sale activities. Now, we expect the FCA to use the duty to increase its scrutiny of sectors hit the hardest by the cost of living crisis, so potentially mortgages and motor insurance. And the FCA has also been open about the importance of looking at the complaints data coming in from consumers across sectors and product lines. So, for example, identifying where the FOS upholds a high number of complaints, which may indicate that either the products or services that a firm provides has failed to meet the consumer's needs or expectations. And that's likely to lead to enforcement investigations being opened in 2024 for potential breaches of the new Principle 12, with the most serious breaches being prioritised. Now, to counter that, what firms should be doing or should start doing if they're not currently doing so is analysing their complaints data to identify recurring problems, trends, uphold rates, which highlights products, services and or communications that may be causing confusion and complaints. And that will allow firms to implement corrective measures in a timely manner and show that the FCA that they are acting on their consumer duty responsibilities. Now, it's also worth noting that from the 31st of July of this year, the consumer duty will also apply to closed products and services. Now, there'll be a few differences in how some elements of the duty will apply. So, for example, the FCA won't expect firms to consider the target market or distribution strategy for products that are no longer on sale, but it will still expect firms to consider if closed products and services could lead to foreseeable harm or frustrate consumers pursuing their financial objectives. So firms with closed products and services should check that they are on track to meet the 31st of July 2024 implementation deadline, and that they are currently doing the necessary work to be ready for that. And where firms aren't ready, then we certainly expect the FCA to take enforcement action in the most serious cases. Now, in terms of ESG, again, consumer protection will be a priority in new rules for sustainable investments. So the FCA's sustainability disclosure requirements will come into force in 2024, starting with its anti-greenwashing rule, which is coming in on the 31st of May 2024. And that rule will require regulated firms to promote products claiming environmental or social characteristics in a way that is fair, clear, and not misleading. So firms will need to upgrade their policies and procedures, as well as their marketing materials, to ensure that they are all in line with this new anti-greenwashing rule, and that they do not overstate green credentials. And this is a topic that all regulators, so not just the FCA, but the CMA and the FRC, are motivated to take action in relation to greenwashing. And we certainly expect the FCA to take sort of swift enforcement action where it believes that serious misconduct may have taken place because of a potential breach of its anti-greenwashing rule. Next slide, please, Dan. So, as I've mentioned already, we anticipate the treatment of retail customers continuing to be an enforcement focus for the FCA going into 2024. In particular, the treatment of customers in vulnerable circumstances who face the greatest risk of harm. Now, in line with that, we've seen the FCA becoming increasingly concerned about financial promotions, and given the significant increase in the potential for consumer harm taking place online, we expect to see more interventions and enforcement action regarding financial promotions by the FCA going into 2024. Just staying on the financial promotions topic, I just wanted to mention that obviously the FCA's new regulatory gateway for firms that approve financial promotions comes into force on the 7th of February 2024. So authorised firms wishing to continue to approve financial promotions from that date onwards will need to submit an application for approver permission to the FCA by the 6th of February 2024. And firms that haven't made an application by that time will no longer be able to approve financial promotions unless an exemption applies or until they have applied for and been granted permission to approve. So again, we may see enforcement action taken against firms that fall foul of that. And lastly, on the financial promotions topic, it's also worth mentioning that from the 8th of October 2023, unauthorised firms wishing to make financial promotions relating to qualifying crypto assets must have their financial promotions approved by the FCA and or PRA authorised persons. So again, we anticipate the FCA will be scrutinising adverts issued by unauthorised crypto assets firms and crypto asset firms generally, looking to ensure that one, they've been approved by an authorised person, and two, they meet the FCA standards. And again, we expect some enforcement activity off the back of that. Now, just lastly on the consumer protection theme, we anticipate a further uptick in supervisory interventions, with the FCA imposing more requirements on firms by way of VREX or OIREX if needs be, restricting the business firms can do until the FCA is satisfied that there is no longer a risk of consumer harm, or where harm has been caused already, then to mitigate that consumer harm going forward. And that's part of the FCA's priority for taking assertive action and acting quickly. Next slide, please, Dan. And just moving on to non-financial misconduct. Obviously, this is quite topical at the moment. The FCA has long viewed non-financial misconduct as misconduct that falls within the scope of the regulatory framework. And given the recent D&I consultations from the FCA and PRA, which proposed to explicitly include non-financial misconduct within the conduct rules, fit and proper assessments and suitability guidance on the threshold conditions, we wouldn't be surprised if more enforcement investigations into non-financial misconduct are opened in 2024, particularly where serious non-financial misconduct has taken place. So, for example, cases that are similar to the FCA's ongoing investigation into Chris Finney for allegations of sexual misconduct. And whilst the consultation proposals will not come into effect until next year, we would probably say, and I think the expectation would be, that the FCA and PRA are likely to take a more active interest in firms, in how firms deal with non-financial misconduct, and how they're sort of factoring that into staff fitness and propriety assessments, for instance. Now, in terms of sort of financial crime, again, this has been one of the FCA's key priorities for a number of years, and we see that going into 2024 as well, with a focus on preventing fraud, money laundering, sanction evasion, and terrorist financing, as well as delivering assertive action on market abuse. So in that context, I mean, it's important for firms, to have their houses in good order. And I suppose what we mean by that is, if we take AML as an example, that's things like ensuring your risk assessments are up to date and fit for purpose, ensuring that your customer due diligence and enhanced due diligence at the point of onboarding is adequate, ensuring that your ongoing monitoring is adequate. Ensuring staff training is adequate, tailored and robust, maintaining, say, an AML log, that there's induction training that's specific to the firm's products and customers, ensuring that remedial action is taken to improve systems and controls where deficiencies have been identified, either by an internal review or an external review, and ensuring that adequate resource and money is invested into that. And I suppose the same can be applied, for systems and controls in relation to preventing fraud or market abuse, and having adequate training, etc., in place, and ensuring that there's effective first, second, and third lines of defence. Next slide, please, Dan. And then just lastly, I just wanted to mention sort of the impact of the FCA's new executive directors on the FCA's enforcement strategy going forward. Now, Therese Chambers has been in role for almost a year. Steve Smart, slightly shorter, but around 6 months. And I think we are starting now to see the early signs of their strategic direction. In particular, the law firm Ashurst reported in October 2023 that there has been a notable uptick in the number of cases by FCA enforcement in response to a freedom of information request that they did. And in that request, the FCA stated that it had closed 37 enforcement cases in the second quarter of 2023. And by comparison, the FCA closed 107 cases for the whole of the 2022-2023 financial year. And the claim that was made that if the FCA maintained its current rate of case closure, it would close nearly 40% more enforcement cases during this financial year as opposed to the previous financial year. And whilst we don't have the latest numbers sort of right now, it'll be interesting to see whether more cases are closed. But certainly we know, from the FCA's annual public meeting in 2023, Therese Chambers was clear that enforcement is actively seeking to close cases more quickly. And I've included a quote from Therese on the slide about closing cases that were always destined to close. And I think it's likely that there are two sort of main reasons for this change in strategic approach. One, in Therese Chambers' first speech and role, she emphasised her desire to achieve a strong alignment between the FCA's enforcement work and the FCA's wider strategy. So closing legacy cases, will facilitate this by freeing up capacity to pursue new priority areas, including consumer duty and non-financial misconduct, which I've already mentioned already. And two, to bring down obviously the length of time it has taken the FCA to complete investigations. As Sona's mentioned before, the FCA's 2022-2023 annual reports, they say it took an average of 40 months for the FCA to complete the investigation stage in regulatory cases. And as Sona has also mentioned, the Upper Tribunal has also stated that the length of the 5-year investigation in the Julius Baer case was unacceptable. And I know the National Audit Office has also concluded that the FCA has been far too slow to take action. And I know from my time at the FCA that the FCA does need to reduce its caseload and reduce the amount of time it takes to investigate. And it certainly seems clear that going into 2024 and beyond, this is what the FCA intends to do. But in order to do that, I think it's going to have to use data and technology more efficiently. So for instance, using complaints data to identify consumer duty cases, whilst also reviewing its investigation and decision making and processes. So that's me.
Thank you all. Just time perhaps for one brief question. I wonder how much of what you've said is an admission of failure by the FCA. What I'll explain that in a moment. And how much do you think then it's using smoke and mirrors to cover that up? The admission of failure seems to be, oh look, we've got all of these open cases on the books and we should have closed them a long time ago, but we didn't. Perhaps that's been because we opened too many matters by shoving them all into enforcement at the beginning when we had our last enforcement director, and we shouldn't have done that. And the smoke and mirrors might be, for example, well, we've certainly cleared a lot, we've cancelled an awful lot of Part 4A permissions, but a large number of those are firms that haven't been trading any law. So we've given the impression of taking lots of action without doing it. Of course, we've outsourced SMCR enforcement to firms, and on the non-contentious side anyway, although we've apparently cleared the backlog of applications for changes to control and new senior managers to be approved, we know that we haven't really cleared the backlog at all. All we're doing is continuing the same old tricks of, well, the clock didn't start yet because your application is not complete. What do you think?
I'll jump in and say I completely agree. I think that the enforcement in the FCA, it needs some quite drastic change before we see the sort of real sort of action that they want to take, and with the speed and the sort of the sort of effectiveness that they've said that they want to take. And I think a lot of what we hear from the regulator about how positive it's been and how much change they've already implemented, you've got to really dig a little bit deeper to work out what's really going on there. Because I think that, to be fair to the regulator, they have taken a lot of action in different ways. And I think it's right that they look at using powers that they have at their disposal in different ways. But what I've seen from my experience is just that they're using intervention powers and sort of enforcing restrictions on business, or sort of forcing businesses to go down the VREC route, when actually that's just not appropriate, and they just haven't really thought about what's the right thing to do for this particular business. And saying we've cleared our backlog when they're effectively just have shut down a number of firms, or just basically put a red thread through a number of applications, I don't think is actually the right thing. It makes great headlines, doesn't it? But
it's making things worse, isn't it? I mean, almost intimidating, I think, to say, or to try to intimidate, to say, we know lawyers like to take big and important points, but they shouldn't.
They shouldn't, exactly.
I think really almost an attempt to bully.
I mean,
Yeah.
I've definitely heard anecdotally from people I still know that work in enforcement, it's much easier to close cases now. So I think there has been that bit of a shift between the Mark Stewart era and this brave new world where, if you're a firm under enforcement, you've been in enforcement for a while, a year or 2 years, it's worth thinking about actually, can we get this shut now? Because it's probably easier than it has been for a few years, for sure.
Thank you. We're out of time, so it just remains me to thank you all, Sona, Seb and Andrew, for taking us through a very interesting session, and to all of our guests for joining us. And we'll look forward to seeing you all again next time.